Welcome back to Winning Law. I'm attorney David Nguyen with offices in Houston, Texas, and today we're going to go over the 7 steps necessary to probate a will in the state of Texas. So if you live in Texas and you have a valid will upon your passing, these are the 7 steps that your loved ones will go through in order to probate your will. The first step in probating a will is to file a document with the probate court. The document is called Application to Probate Will. What this document does is that it identifies the decedent or the person that passes away, informs the court that they have jurisdiction over the case, and that the person had a valid will in place. When you're filing the application to probate a will, it's always a good idea to ask for letters testamentary. So when you go for your hearing on this matter, the judge is going to assign someone to act as the executor of the estate, or a person that's supposed to distribute the estate or the property. So it will be very inconvenient if this person is unable to collect the estate in order to distribute it. So what the court does is that if you request letters testamentary, they will issue you a letter. That way you could present it to creditors, you could present it to the banks or other institutions in order to gather all of the decedent's property. The second step is merely waiting for the probate court clerk's instructions. Usually the clerk will send you these instructions either by email, or they will call you, or they will send you a letter. Usually they will ask you to upload a copy of the death certificate, a copy of the will, and any proposed orders that you want the judge to decide on at the time of the hearing. The third step is to file the original will document at the probate court. So when you go and you file it, I usually recommend that you receive some type of receipt or confirmation that you properly filed the original document. This document or the original will must be filed within a specified time. So make sure that you double check and you ask the probate clerk how much time you have to file it after filing an application to probate will. The fourth step is that you have to attend the probate hearing. So at the probate hearing, the probate judge will review the application for probate to make sure that everything looks good, and then they're going to review the will to make sure that it's valid and enforceable, and then they're going to designate the person that they deem as the executor or the person that's going to distribute the estate. In addition, if you requested letters testamentary that we mentioned earlier, they'll put in an order for you to receive those letters. Step 5 is that after the hearing, either the probate judge or the probate clerk, they're going to notify you to file certain documents with the court. So again, every county has slightly different probate rules. So most counties will tell you to file things like the proof of death and other facts, and also the oath of the independent executor. But certain counties, for example, we just did a case in Fort Bend. In that particular county, the court actually requires you to sign a document called court rules or court regulations, and then upload that as well. So again, pay attention to what the probate clerk has to state, because it could be different from your county versus a different county. Step 6 is that you have to notify certain individuals. This includes publishing an ad to notify individuals or the public that the probate process is going on for that individual. You can easily contact the probate clerk and they'll tell you which publisher they recommend. You also have to notify certain creditors and also any potential will beneficiary. The final step in probating a will is that the executor or the attorney handling the estate, they're going to file documents stating that they have done what they were supposed to do as the executor of the estate, such as they're going to file documents like the order of inventory, stating that they have gone over the estate and they distributed the estate to the correct beneficiaries. They're going to publish a notice to creditors stating that they notified all of the creditors that may have an interest in the property. They will also publish an affidavit of publication, letting them know that they published the ad in a newspaper, that the probate process was going on, and also a notice that they notified all of the will potential beneficiaries. So this is what the executor or the attorney handling the estate will file at the very end. And after that, you're done probating the estate. Thank you for watching Winning Law. I'm attorney David Nguyen, and we hope that we have made the probate process easier to understand.
At David Nguyen's Law Office, we are here to help you We bring families together through immigration. And on the other hand, we help you find solutions. All your legal needs in the hands of people who care, who are there for you. We'll take care of your loved ones at the law office of David Nguyen.